Now, the first one that we have for the discussion from the community is from the Rhode Island League of Cities and Towns. Brian Daniels and Mayor Lawson will give recommendations centered on improving the hearing panel. So is Brian or Mayor Lawson available? Because we certainly would appreciate hearing from him.
I'm here, Senator. Good afternoon. How are you?
Good, thank you.
And so I want to say good afternoon to all the members of the committee, and particularly you, Chairman and Senator Metz. I really appreciate you taking this on, because this is a moment that's truly calling out for reforms. And representing the Rhode Island League of Cities and Towns, we do believe that there are important reforms that can be made to improve the entire process. So thank you, Senator, for convening us. I also before I get started, I want to acknowledge that there were a number of representatives from cities and towns throughout the state that came together and they worked really hard as a subcommittee to put together these recommendations. And I want to recognize them for their work. Joe Almond, Town Administrator from Lincoln, Steve Contenti, the Bristol Town Administrator, Christopher Cotter, the Tiverton Town Administrator, Karen Pinch, the Richmond Town Administrator, and Michael Wood, the Burrillville Town Manager. And they all served on the subcommittee, and we brought this to the entire group. So more than anything else, what these recommendations represent, they represent the views of the Rhode Island League of Cities and Towns. That's all of us collectively speaking with one voice. I do also want to share that we met with the Police Chiefs Association, and as I understand that this committee has as well. And in certain sections, our recommendations track their suggestions to a T, but in other sections, we go and we push for recommendations that extend beyond the recommendations that they made. So to summarize what the rest of this report will be, and we strongly support extending the threshold for when LEOBoR kicks in from the current 2 days to 10 days of suspension. We also strongly support improving the transparency in the process and being able to speak publicly about incidents throughout the process. We also are concerned about the retention of discipline records and believe that they should be retained. And last, along with the police chiefs, we also believe that there should be improvements to the process of the LEOBoR process, but we make specific recommendations that we ask the committee to please take into account. So we appreciate this audience and this opportunity to be heard. So starting on the first issue on the threshold for when LEOBoR appeals kick in. And currently, as we know, it's 2 days. We strongly support increasing this to 10 days. And the majority of the police chiefs and the cities and towns, we all agree that increasing the number of days for when LEOBoR is triggered will obviate the need for much of the reforms in the process thereafter. Because in a survey done of the discipline cases over the past 5 years, we see that the overwhelming majority of disciplines are within this 0 to 10 days. And oftentimes the disciplines, they don't lead to suspensions. Sometimes they're for administrative tasks. But if we could extend that threshold to 10 days, it would leave very little disciplines to even be eligible for the LEOBoR process. As a committee, we also talked about extending it beyond 10 days and whether that would be helpful. And it was the view of the entire committee that extending it beyond 10 days really wouldn't be helpful, because it's rare that police chiefs discipline officers beyond 10 days. Once you get to that point, you're essentially disciplining the officer by moving towards termination. So the 10 days would obviate the need for much of the further reforms in the process, and would be a strong message that this committee and the General Assembly would send, that we trust the judgment of police chiefs, and we are not too concerned about police chiefs overzealously at disciplining their officers. in effect, what we'd be doing is deferring to their judgment. And this would be a big deal. This in many ways would be a game changer as a reform to the LEOBoR process. The second area that we asked the committee to consider reforms is when it comes to greater transparency in our ability as a police department and as a city to comment publicly on these cases, especially when there's possible criminal acts that are involved. Now, we do believe that there is some wiggle room where police departments and municipalities can currently speak when there are criminal issues, but it gets very challenging when when the conduct may not rise to the level of criminality, but is out there in the public domain. Perhaps there's a video of it that we're asked to respond to. In that position, simply saying we can't respond because of LEOBoR just isn't cutting it, and it really erodes trust if we can't be transparent and to at least say that, yes, we are aware and there's an investigation that is undergoing. So we ask the committee to please consider some reform to allow for greater transparency in the process. And this is particularly important as we're going through this moment in law enforcement today, that people are demanding, and rightfully so, greater and greater transparency from all of our offices. So we see this as incredibly important as a reform to be taken up. An additional concern that we highlighted as a committee is as concerns the disciplinary records that are maintained by police departments, and the fact that sometimes they are sealed and or expunged. And the concern here is that potentially this allows officers to either reset the clock on progressive discipline within their departments, or it allows them to be hired by another agency with a clean slate. And that certainly doesn't serve the public interest if there's backdoor ways to get out of previous complaints and previous disciplines. We believe that police departments should retain all records of an officer's disciplinary history. So the last piece that we would like to discuss is simply improving the LEOBoR appeals process, including the composition of the LEOBoR board. We strongly believe that going through the LEOBoR process is cumbersome, it's lengthy, and it's expensive. And the fact that it's cumbersome, lengthy, and expensive does indeed influence many of the decisions that are made by the police chiefs. Even if the police chiefs hands out a level of discipline that doesn't take into account the potential LEOBoR process, we found that in many instances, in fact, I want to say the majority of instances, that the police chief and the officer negotiated down the discipline to a point where the officers accepted it, and they accepted it willingly. And on the other hand, the police chiefs accepted so that they don't have to go through this process. This undermines trust in the entire process, because I believe we should trust police chiefs' judgments to dole out the right level of discipline. And the fact that they're reducing their level of discipline simply to avoid the LEOBoR process isn't a healthy step here. Police chiefs have also noted to us that the reality is that very few cases actually make it to a full hearing and then a decision. So we're really talking about very, very few cases. And in all truth, if the threshold is increased from 2 to 10 days, then there'll be even less opportunity for cases to make their way all the way up to a hearing. Nonetheless, we do support changing the composition of the hearing committees and expanding the representatives on this group from 3 to 5. And I'd like to explain a little bit of our thinking on how we landed at this place. Now, I understand that there is no magic number, whether it's 3, 5, 7, 10, whatever it might be, there's no magic number that solves for all of the issues. However, we do believe that how it's currently comprised of 3 people, where under the current statute, one of them is a representative from law enforcement, one is one is designated by the officer, one by the department. With such a small group of 3, and those 2 individuals seeing themselves potentially as advocates for the folks who appointed them, it has a disproportionate and overwhelming impact on the deliberations of such a small committee. In committees that we have served on, and I'm sure folks here have served on a number of committees, that usually when you get down and talk through the nuances of the issues, very often there's unanimity that comes out of those conversations and discussions. And we believe that by expanding the group to 5, that there'll be more of a professional character to these hearings, and hopefully, as the issues are considered, it will get either to unanimity or as close to it as possible as these hearings are conducted and decisions rendered. We recommend that the officer and the police department still be able to recommend one person for the committee. But we also recommend that the 3 other officers be appointed by the court and that they be a standing committee. Having them be a standing committee, we believe, will go a long way to making sure that some level of jurisprudence and stare decisis begins to apply, so that there's a track record, there's precedent that's set, and that effectively signals to officers in the future and to police departments in the future where it is that a decision would come down. Whereas now, since it's such an ad hoc committee, there's a lot of uncertainty of where the committee would land if it does go to a full hearing and then a decision. So professionalizing the process would be very important, and we strongly advocate for that. And last, we advocate for certain changes to the process, beginning with pre-hearing discovery rules. We believe that they should be reciprocal. As it currently stands right now, the departments do not have the same full rights to discovery as the police officers do. We believe it's just fair for us to be able to do discovery just as the police officers are able to do. We also believe very strongly that there should be a shared cost involved. Any of the costs involved throughout this entire process should be shared equally by the department and by the officer. And we also believe that any witness statements and other evidence that's intended to be used should be produced beforehand, and that should be handled evenly on both sides of the matter. So, we truly appreciate your consideration of each one of these recommendations. We appreciate your looking at this entire law and process. And on behalf of the Rhode Island League of Cities and Towns, we stand here and offer our services going forward to either bounce ideas or also make additional recommendations in the future as you all might see fit and find helpful. So we truly appreciate your time and look forward to continuing deliberations, and are here to answer any questions that you may have.
Yes, you have heard Mayor Laws' presentation on behalf of the cities and towns. Is there any questions for him?
I have one. Mayor, this is Jim Vincent.
Hi, Jim.
Hi. As you may or may not know, there's a bill in the House that would increase the days from 2 to 30. Was there any consideration in terms of that time period going from 2 to 30? I think I remember the last presentation where I think even the police chief said that they had talked about 10 to 15 days, something of that nature, which was more than 10, or maybe less than 30. But 30 seemed to be a number that, at least in one of the House bills, they seemed to feel would be the happy medium between the officer and the chief. Why not go to 30?
That's a good question, Jim. And then we did speak about that and think about that for good discussion within the committee. And the reality is that we all believe that there frankly would be no difference between 10 and 30, because there are very few instances where police chiefs discipline officers with more than 10 days of suspension, right? By the time that their conduct becomes that egregious that it requires, say, 10 days of suspension, it's so egregious that the chiefs usually recommend full termination. And so you're going to find very few cases that fall within the 10 to 30 range for suspensions. So it really doesn't make a difference. And I'll come back to this basic point that, LEOBoR, as you get, LEOBoR is a bit of a misnomer, right? It's not really a Bill of Rights for officers. And there are some procedural protections, but at the heart of it, what LEOBoR is about is how much do we trust police chief's judgment, and how concerned are we that the chiefs are going to discipline in arbitrary and capricious ways that are greater than what's called for. To the extent that we trust police chief's judgment, and we trust that there's a process in place that if a chief is going overboard, that chief can be replaced. To the extent that we're not concerned about any of those, then there's less of a need for LEOBoR to begin with. And this all comes down to how much do we trust police chiefs. And we have a high degree of trust for police chiefs. And I think that that's what extending it from 2 to 10 days or 2 to X days, whatever that turns out to be, will go a long way to telling our chiefs that we trust them and they're in the best position to dole out discipline as anyone else involved.
Mr. Chair, I have one follow-up question.
Yes.
It's regarding the composition. I've heard people in the community say, well, you have the officer, they're able to pick, one of their judges, one of the 3. Of course, the department also can pick, somebody, one of the 3. So you got a neutral. So really, everybody's trying to get the neutral. Was there any consideration, and that neutral is from the courts if the 2 sides can't agree? Was there any consideration of maybe having 5 neutrals appointed by the court, and that way neither the officer or the department gets a chance to pick a judge, but it's 5 neutrals from the court, and I'm just wondering whether there's any talk about that kind of change in terms of composition.
Yeah. Thanks for the question, Jim. Really, really, really good questions. And the police chiefs did some research. They surveyed 23 departments. I imagine that the police Chief Wardell, presented to the committee, but just in case he didn't, over a 5-year period, there were 750 cases of discipline. 488 of those disciplines required no suspensions. So we're talking only about 262 cases where there actually were suspensions. Of those 262 suspensions, 152 of them were for 2 days or less. So now we're only talking about just over 100 cases where there were more than 3 days, and the overwhelming number of those 100 or so cases were within the 2 to 10 days. It turns out that in all of these cases, there were only 5 over a 5-year period that actually made it to a full hearing. And going back to previous years, in 2019, there were only 2 instances where a neutral had to be selected by the court. In 2018, there were 0 cases. And in 2017, there was only 1 case where a neutral had to be selected by the court. So, I wanted to go over that just to underscore this point that I do believe that changes to the process and changes to the composition of the hearing board are incredibly important. But the changes to this time frame for when LEOBoR kicks in is even more important. So going to the point of the composition of the board, what we recommend on behalf of the Rhode Island League of Cities and Towns is increasing the neutrals from 1 to 3. And we believe that increasing it to 3, there's just greater possibility that they will all truly be neutral, and that these decisions won't swing simply on do you get the right person or the wrong person on there. Whether it's 3 people who are neutrals or 5 people who are neutrals, there's no magic number, and I think that either one of those would work. But we do believe that increasing the number would help in the entire process and would help professionalize it as well. We recommend 3, but we defer to this committee. If you all believe that 5 neutrals make sense on top of 1 from each, that's perfectly fine. But increasing the hearing committee number, I believe, will help.
Thank you.
Any further questions for Mayor Lawson? Okay, thank you, Mayor. We appreciate your time and that presentation. Thank you so much. We appreciate it.
Appreciate your consideration. Thank you, Senator.